What's up, co-counsels? I'm exhausted, you guys. I'm done. Really tired. I'm really tired, but I'm reliable. I said I was gonna be here, so I'm here, okay? Probably I doubt I can even make it an hour because I'm really exhausted. In any event, there are new developments in the Karen Reed trial. Okay, so we're gonna switch it up a little bit because today we were scheduled to talk about we're scheduled to talk about juries. But that's we have a ruling. Okay, we have a ruling from Bev Canoni, so that's what we're going to get into. Okay, so I have the actual order, but I'm not gonna pull it up here because again, I don't want to inadvertently disclose information I should not, or personal information that I should not be disclosing. But before that, though, no, let's actually get into this because I don't have time to be up here for too long. So let's see. Let's get into. I should have brought my glasses because I actually cannot see. Hold on. Let me figure out how to increase uh, the font. Okay, so let's get into it. As far as Canoni's rulings from or order from today, the focus is more so on, it's more of a limitation, really. It's a limitation on her ability. It's not really her ability to, raise a third party culprit defense, but so it's more so how many she can call. Okay. So I'm going to read the order in a little bit. I've not read it myself, but I'm aware of what's going on. Before we even really get into the order, before we get into the substance of the order, you guys know how I felt about defense pointing the finger at three different individuals. In my experience, a third party culprit defense works best when usually it's one suspect. That's when it works best. From my perspective, I think that Bev actually did Karen a favor under these circumstances because the three individuals, I don't know, it was just a little too questionable for me. So narrowed it down to two. I still find it problematic, but let's get into the actual order. Hold on. Okay. So this is memorandum of decision and order on Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. The Commonwealth has moved to preclude the defendant from raising a third-party culprit defense. The defendant has alleged three potential third-party culprits: Brian Albert, Brian Higgins, and Colin Albert. For the reasons that follow, the Commonwealth's motion is allowed in part and denied in part. So I don't really want to say that she split the baby, but let's get into it. So Canoni says the opportunity to present third-party culprit evidence is guaranteed by the Due Process Clause of the 14th Amendment because it is rooted in the right of criminal defendants a meaningful opportunity to present a complete defense. And they go on to cite some case law. A defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity to commit it. And then again, more citations. However, the defendant's latitude to introduce such evidence is not boundless. So I guess that should have been key. That was Canodi's signal that, um, there's a limitation as to really to both parties because she kind of split the baby. So the defendant's ability to mount a third party culprit defense is not without limits. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible provided that it has substantial probative value and will not tend to prejudice or confuse the jury. They cite more case law, at least authority. Proffered evidence must have a rational tendency to prove the issue the defense raises, and the evidence cannot be too remote or speculative. So she goes on to tackle Colin Albert. Okay. As to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, and opportunity to commit the crime. As far as the first trial was concerned, I personally, I mean, if I'm saying I, it's personal, but I just did not see. I think it was a little too attenuated as far as Colin is concerned. Sure, the defense introduced, I suppose it was specific instances of him being violent or him supposedly having violent tendencies. I just did not buy it. The evidence of opportunity is wholly inadequate. There is no evidence that Colin Albert was at 34 Fairview when the defendant and Mr. O'Keefe arrived at the home. Oh, what I actually found interesting, I took a look at some of the defense motion. They're pretty old motions though. If I remember correctly, some of the date I got distracted. Yeah, I always get distracted. When I was looking at some of those dates, I believe 2024 after the trial had concluded and 2023. What I found, it's not that interesting, but I was comparing their style, or at least the fan style of writing, to my own style of drafting. They refer to, or they prefer for their client to be referred to as Miss Reed, which is different from the way that I do it because I go by first name. Okay. I usually go by first name or nickname. I think it's more personable. If somebody's William, maybe the first time I talk about the client, I'll say, I don't know, William Phillips or something. I don't know. Those are like two first last names and first name. I don't know. Confusing. Anyways, William Phillips or whatever. But after that, I'll call them Bill. So I just thought they were pretty formal. Anyways, third party culprit evidence properly excluded where there was no evidence. Third party had means or opportunity to commit crime, and evidence of motive was speculative and too remote. Evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. I still personally think that Kanoni um, she did Karen a favor, okay? Because um, the defense, obviously, they wanted to point fingers at all three, but from I don't know, from a juror perspective, from a fact finder's perspective, I think it makes sense to actually narrow it down as opposed to having three different individuals that weren't doing it at the same time. For the two Bryans, maybe, but as far as Collins, I thought that was too attenuated, and because he is removed, there's probably a stronger chance for more jurors to actually believe that it's somebody else other than Karen Reed. And then, as to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans, oh my goodness, what a mess, on O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial. Even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate third party culpability. All right. And then they have a footnote. It's too tiny. I don't have my glasses, so I definitely cannot see that. Facts of tension between the neighbors and victim was not indicative of the neighbor's motive to kill, and the defendant offered and produced no evidence suggesting that the neighbor had any opportunity to kill beyond that possessed by any neighbor. Moreover, the theory that Colin Albert is a third-party culprit because he had scraped knuckles, ASAP Rocky, and Takapina. I will forever associate scraped knuckles with Joe Takapina. I just will. Okay, so Moreover, the theory that Colin Albert is a third party culprit because he had scraped knuckles at some point after O'Keefe's death had been seen in a video drunkenly. How old is he? I don't know. I guess you can drink. Mm, some people do drink even when they're not old enough. Anyways, taunting others with no connection to O'Keefe and apparently was not named in police reports is speculative at best. Third party culprit theory: the victim was shot by unnamed rival. This is citing a case, okay? Unnamed rival drug dealer was based on rank speculation and properly excluded. So evidence that rival gang, it's another case, okay? Commonwealth v. Andrade, 2021 case. Evidence that rival gang members lived near shooting and were involved in feud with victims, not sufficient to support third-party culprit defense, where there was no evidence that they had been nearby at time of shooting, and theory was speculative at best, allowing such feeble uh, Bev said it's feeble. Third party corporate evidence poses a risk of unfair prejudice to the Commonwealth and would only serve to confuse the jury. And then she cites Silva Santiago. Accordingly, the evidence that Colin Albert is a third party culprit is excluded from trial. The Commonwealth's motion in limine is allowed as to Colin Albert. But again, here's the thing: if an individual what's up, Benji? What's up, Brooklyn? Brooklyn, my weekend was I worked. I worked all weekend. I'm exhausted. I don't know if you guys can hear it in my voice or not. I am tired. I'm tired. I worked all of Saturday. What else did I do on Saturday? Oh, my daughter and I we had a road trip. Okay, we had a road trip, but after that, I had to work. I worked until probably 1 or 2 a.m. on Sunday. And then I got up. We went out for a little bit. When we got back, I worked some more. I put in so many hours. Yeah, I worked. I worked a lot. And then I went to bed. I went to bed past midnight. I went to bed like at 12:30, and I had to get up at 5:30. I'm tired. I'm tired. I'm not functioning properly. When I got to work, I still had to work on my opposition a little bit. I worked on my opposition. I got my exhibits together because the paralegal that this case is assigned to is on vacation. So I had to get all my stuff sorted out, but it's done, and I'm relieved it's done. It's done. I get to move on to other cases, but that was my weekend. But I'm really tired because I worked all weekend. What's up, Benji? Okay, so Benji has been working too, and Benji's at work right now. Big shout out to Benji. Okay, yeah, but I know. How was your weekend, Brooklyn? How's your weekend, Benji? But I'm tired. I'm tired. Let's get back to this order. Did I just pull up a different? I have too many tabs open. There's going to be a point when I have to close some of these tabs because I have too many tabs open. I cannot find. I cannot find. Hold on. I'm gonna find it now. I cannot find the order. Okay, there we go. So as to Brian Albert and Brian Higgins, the defendant's proffer is barely sufficient, she says, so barely sufficient. And the history of the first trial casts doubt on the seriousness of the claim. However, to protect the defendant's right to a fair trial, and in recognition of the fact that the defendant has no burden to prove anything under our law, the courts will take the same incremental approach as it did the first trial. Defense counsel are ordered not to mention potential third party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. Okay, though the court may ultimately exclude the proposed third party culprit evidence or counsel may abandon the theory, that does not mean that the defendant cannot offer the evidence to show the inadequacy in the police investigation, provided that the proper foundation has been established. So I guess Kanoni is covering her bases here. And what I mean by that is because she's basically um, I guess she is anticipating, in the event there's a conviction, she's anticipating a challenge as to her order, limiting third party culprits. Okay. So, right off the bat, she's pretty much telling defense that I am not restricting you from challenging, what is this? The proper investigation or really inadequacy. Or the inadequate investigation by law enforcement in this case, and you can certainly bring it up just in case they're just in case the fancy is pretty much prepared to, not even pretty much prepared. The fact that Canoni ruled in part for the prosecution or the Commonwealth, if she does get convicted, they've pretty much preserve this issue for appeal. Okay, so order. It is hereby ordered that the defendant is precluded from raising a third party culprit defense alleging Colin Albert is culpable for John O'Keefe's death. The Commonwealth's motion is allowed as to Colin Albert. The defendant is not prohibited from raising a third party culprit defense as to Brian Albert and Brian Higgins at this time. Counsel cannot mention potential third party culprits in the opening statements, but will be given the opportunity to develop the theory through relevant, competent evidence at trial. Then she just repeats. She just repeats herself. All right, let me. This footnote's too tiny. I cannot read that, but there's a footnote at the bottom of that page. But let's quickly go back. I'm going to go back to Colin Albert here. Okay, and I'm going to go back to Colin Albert. Let me see. So Benji says road trips are nice. It's nice to get out. Yeah, it was. It was pretty nice. And what else? We stopped at a gas station. We stopped at a gas station to get some snacks. That's usually how we do it. And we bought stuff we really had no business buying. And I had a Red Bull. I've not had a Red Bull in years, though. I've not had a Red Bull in years. Uh, that's because caffeine makes me sick and Red Bull gives me backache. But I had a Red Bull because I was in a store spending money I shouldn't be spending and buying things I shouldn't be buying. So Brooklyn's son got engaged. Woohoo! He proposed Thursday, emailed you a picture. I'll take a look. Thank you. Um, I why did I always think I think Brooklyn does have, I don't know. I always thought that you just had daughters and they were young, about my daughter's age, or maybe teenagers. But congratulations, Brooklyn. That sounds like a fantastic way to spend your weekend. All right. So let's quickly go back up here to Colin. I mean, I could share my screen, but I'm just worried about just closing. Let me see. Maybe my email doesn't pop up. But if it pops up, then I have real problems. If it pops up, I have real problems. So I'm gonna let it go. Gonna let it go. Okay, so I'm just gonna go back to Colin Albert. Okay, I'll put the link. Let me put the link in the chat. That's how I should be doing it. Okay. I'm gonna put the link in the chat. Okay, so that's a link for the document, the order that I'm reviewing. Okay, so Brooklyn has girl, boy, girl, boy. Oh, okay. All right, Brooklyn. All right, I'm gonna go back to Colin Albert. All right, and this is page 2. I'm taking a look at some of the facts or the underlying, really the underlying facts that Canoni is relying on in issuing her order. All right. That's what I should have done. I guess I should have looked up defendants proffer, or at least their response to the Commonwealth's motion in limine. In any event, I'm looking at the part to where Canoni is saying that the evidence is inadequate. Okay, So there we go. There was no evidence that Colin Albert was at 34 Fairview when the defendant was there. Okay. Um, that's one part. Okay. And then the other part, pretty much he's saying that evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. So, from my point of view, I still think that um, here's the thing. I understand it from a defense perspective because I've defended criminal defendants before, and what it appears like, you don't really know what's going to stick. Okay. I mean, the prosecution also does not know what's going to stick, but you do want to have a coherent theory. All right. Uh, And I am of the opinion under these circumstances that a defense attorney, I'm under the opinion that defense attorneys were not really editing their theory. And that's why I still think that Bev Canoni actually did um, Karen Reed a favor with this order, because here's the thing: if the defense cannot point to Colin, I was going to say Colin Griffith. Who's Colin Griffith? I think, isn't that the kid out of, no, not California, I think Florida or something? In any event, um if the defense cannot point to Colin Griffith, no, why am I saying Colin Griffith? What's his name? If the defense cannot point to Colin Albert as a potential third party culprit, right? Then the jurors do not have to consider all these inconsistencies. Okay, so the jurors do not on their own have to come to the reasoning that there's no way he could have done this because he was not even on the premises at the same time, right? So it, based on this order, all right, the jurors will not have an opportunity to undermine the defense, third party culprit theory. All right, so that's just one person removed. I personally think, um, again, there's no way defense would have reached this decision on their own, because in their mind they want to point to all three. In my mind, as a licensed attorney that's done both prosecution and um, criminal defense, I still do not think that they edited themselves or their theory or their work properly, because the three individuals, here's the thing with third party culprit, with a third party culprit defense, a juror is much more likely to believe it um, if it's one person. And if it's not one person, they're much more likely to believe it if a defense can somehow show that these individuals were working in concert. Okay, not that the defense has any. I mean, sometimes defense does have an obligation when it comes to criminal cases, but obviously under this case, the burden still lies with the prosecution. But for me, defense having all three individuals not showing that they were acting in concert, that just undermined their defense. That's from my perspective. Okay, and then where's the other, my eyes, I just cannot see. I need a bigger screen. I just need my glasses, but I cannot see. And then again, this whole thing about, motive and him or Colin Albert having a propensity to engage in fights with people, I was not buying their first trial, but I, I think I think this editing works out for Karen Reed. That's my own reasoning. People that are like staunch supporters of Karen Reed are not probably going to see that, and the reason they won't see it is because defense wanted to point to all three, and if defense wanted to point to all three, they might reason that that is the right approach. But I do not agree. I don't agree with that. And then Brooklyn says, "Oh, Brooklyn, I actually watched your video. not your video, but you send me a link. You send me a link. What's the Fannie Willis? Actually, I finally got to watch it. Finally got to watch it, but let me get back. You guys know I get easily distracted. Okay, so Brooklyn says, from what he read on Twitter, uh, it seems that Colin is being removed as um, a culprit was more a financial liability. What do you mean by that? He wasn't in the house or close by, and they defamed him. No, how would that make? How would that be beneficial to Bev Canoni? Because Bev Canoni is the one that's actually making the ruling. I personally think this helps Karen Reed because her third party culprit theory, uh, it was too attenuated. And again, I've said it before, even before what is this the court's order, it just to me it just didn't make sense. It didn't make sense for to claim that all three individuals were potentially liable or caused on John O'Keefe's death. There's a case that I've been trying to think of. It's an kind of an old case, but maybe recent within the last 10, 15 years. It was a high profile case. I just for the life of me cannot remember who the criminal defendant was. But it was a case that dealt with, or at least the defense wanted to introduce third party culprit liability or defense. But in that case, the judge actually did not allow them to. Anyways, here's the other thing. Actually, I looked up the provision. Okay, let me get on my phone. All right, so this is pretty much Massachusetts rules of evidence. You guys know I like to cite stuff, okay? So it's the Massachusetts Rules of Evidence 1105, and it tackles third party corporate evidence, okay? So here it says that evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible provided that the evidence has substantial probative value. In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative. And that's what Canoni did, okay? And that it will not tend to prejudice or confuse the jury. If the evidence is otherwise inadmissible, the court must also find that there are substantial connecting links between the crime charge and a third party, or between the crime charge and another crime that could not have been committed by the defendant. All right. And then the font gets really tiny, so I cannot, my stigmatism will not let me read this. Okay. Uh, I mean, they go on to cite. Oh, this is actually some of the cases. These are some of the cases that Canoni cited. Okay, and then they talk about rebutting third-party culprit defense, where the Commonwealth seeks to. That's DNA. We're not even going to get into that. Okay. Okay, and then they talk about Bowden, which is basically Canoni. Then Canoni telling the defense that, they can get into inadequate investigation. Um, all right, there's something else I wanted to look up. Hold on. I see you, Brooklyn. I'll get to you eventually. There's another motion here, or at least an order that I wanted to look up. I have too many tabs. Here's what I need to do this weekend. I need to close this weekend. I'm gonna have to close some of these tabs down. I have too many tabs. I cannot find what I'm trying to find. And I'm like that. I'm like that on my phone. On my phone. Luckily, Google Chrome has this feature where um, tabs that have not been opened within or read within 30 days, they kind of get archived. I have hundreds, hundreds of open tabs on my phone, on my work computer, on my personal computer. I just have open tabs. And some of these things I don't even get to, but let's see. Hold on. I cannot. Yeah, and I have too many tabs. I have too many tabs. I'm gonna have to close some of this stuff down. But pretty much they're just talking about Colin Albert. I think this is a great. It's great for Karen Reed, but if they're pouty and they're not able to edit their own work, then they don't see it. Oh, here's the other thing that I wanted to talk about. Okay. So Karen Reed cannot call the ex FBI agent to testify as an expert at the trial. I actually would have been very, 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 very surprised if Bev Canoni allowed this individual, I believe his name is Easter or something along those lines. Let me see. If they had allowed this guy to testify, I would have been really shocked. Okay, so this is from Boston. Listen, the the local paper over there, they literally have a section dedicated to Karen Reed. Okay, it's like, anyways, let's get on. So the judge in the Karen Reed trial isn't allowing her legal team to call a former FBI agent to testify about what policies police didn't follow at the scene of John O'Keefe's death in Canton, Massachusetts, in January of 2022. So Bev Canoni on Monday granted the prosecution's motion to exclude former FBI agent Michael Easter as a defense expert witness, finding the jury will be able to figure out whether the police investigation that led to Reed being charged with murder followed standard protocol. Through zealous cross examination, I believe this is what. Oh, never mind. Through zealous cross examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures and can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. So that's Canoni's reasoning. And then apparently, special prosecutor Hank Brennan said bringing an outside law enforcement agent to go over the investigation was Monday morning quarterbacking, okay? And that Easter would be speaking as an expert in a way he's never done before, essentially only summarizing the defense team's arguments. I really, again, I would have been very, very, very surprised had Bev Canoni allowed this person to come in. Brennan also asked whether prosecutors could bring in a state police expert to validate how the investigation was conducted. Okay, so they're just pretty much talking about, or they're summarizing what was that? The hearing that we actually watched. Was it last week, the week before? I don't know. Everything's a blur. Okay. So Jackson noted that while his team, yeah, they're just summarizing. We watched that, but I guess I'll read it for completeness. Jackson noted that while his team could find no previous case in Massachusetts where a law enforcement agent had testified in this ways, it happens in other states. It's supposed to be persuasive, I guess. Canoni was not persuaded. Okay. And then Canoni wrote, the court cannot find, nor has defense counsel cited on Massachusetts case where an expert was permitted to opine in the general competency of a police investigation. The lack of authority suggests that during all the jury trials where the defense has been inadequate, police investigation based on a legal precedent known as Bowden, expert testimony has not been needed for the jury to be able to evaluate the reliability of the Commonwealth's case and whether any failures in investigatory steps are sufficient to create a reasonable doubt of the defendant's guilt. So that was the end of that. But I had to catch up. And when was that? Let me see. Today's Monday, right? On Friday, I see that on Friday, what's his name again? My mind is fried, you guys. I really need to call it a night. Yeah, let's do that. What time is it? Wait, what happened? Hold on, I'm getting distracted. Oh wow. Okay, you guys know that I've been watching the NC hold on. Yeah. Wow, Olivia Miles. Dang. I thought she was going to declare for the draft. Anyways, let's move on. On Friday, I saw that Hank Brennan was in court on the Turtle Boy stuff or the text messages. Uh Hold on. I did not get to watch it though. Friday was crazy for me. Friday was really crazy. I cannot see. My eyes are done. My eyes are done. Law and crime. I think it's crime trials. I think yeah, 3 days ago. So I tried because I was trying to find I was trying to find a video to play in the background as I was doing with the other one. And I thought this would work, but it was only, like 30 minutes or so. So that was not going to work. But I did not watch this, and my brain is literally fried right now. So what did I just do? Shoot, I just clicked on something. My screen disappeared. Hold on. Okay, there we go. Yeah, so this is going to be a short live because I'm done. I'm beat, you guys. I'm beat. I did not have a weekend. So Brooklyn says, can YouTube content creators be liable for such a case? Do you mean when you're saying such a case, are you referring to Colin Albert and people, not people, but some content creators suggesting that he caused the demise of John O'Keefe? Is that your question, Brooklyn? I'll wait for you to answer, and I suppose I'll play this just a little bit. Let's see. I know. Do we have?
And
Oop,
uh,
hold on. Pause. Do we have? I suppose Bev Canoni did rule on every outstanding matter. I'm just trying to see if there's anything else that had to be covered, but it makes sense for her to have issued orders and everything in time for jury selection. And there's a juror questionnaire. I suppose we go over it. We can go over it tomorrow. Okay. As far as today, I am fried. I'm really fried. It's kind of rare because usually on Mondays, I'm usually energized, but that's, I suppose, when I've actually had a good weekend. I was way too busy. I was too busy this weekend. I hope, let me see, but this case is going to be a headache for a long time. So maybe my weekends will be disappearing. But at least it's done for now. Okay, so Brooklyn wants to know. Okay, so Brooklyn wants to know as it relates to what is this? As it relates to Colin Albert. Yes, YouTubers definitely can be held liable for defaming individuals, even I suppose Colin Albert and other folks. And that's why for because here's the thing, people a lot of times you'll watch a YouTube video and they have, some disclaimer talking about fair use at the very beginning of the video. What people do not realize is that fair use does not prevent you from being sued. Fair use is a defense when you get sued, okay? So you'll end up in court for fair use to actually mean anything. Right. And what's the other thing? Oh, here's what I was gonna say. Typically for YouTubers with big YouTubers with, a lot of subscribers and folks that actually make money on YouTube, it's always advisable for them to actually get insurance, okay? Get some type of coverage. Get media insurance to make sure that you're insured so that if you do get sued, because a lot of people, listen, a lot of people that make money get sued. And the reason for that is because They have money, they have assets. So if a plaintiff were to succeed, they can recover. They can recover. They can recover damages. In any event, so yeah, typically YouTubers that run their channels like businesses, like actual businesses, always advisable for them to actually get um, coverage, defamation coverage, in the event that they do get sued. So hopefully that answers your question. I know that was a long response, but yes, folks can get sued. Okay, right. So Lori was in court today. I did not get to watch it. I saw that she was in court when I got home, so that was already after 5. Oh, time difference. So I suppose she was still in court. I just did not have the energy to watch it because I'm burnt out today. So we can get into that tomorrow because I do not know. There's no way. Oh, Lori's trial begins tomorrow as well. That's a bummer. That is a bummer. Yeah, her trial begins tomorrow unless something happened today. But I believe she was scheduled for April 1st as well. I did not get to watch it, Brooklyn, but we can certainly get into it. We can get into it tomorrow. Okay. Yeah, folks, I'm going to call it a night, Brooklyn. I'm going to review your email, and then I'm going to iron and call it a night. I'm tired. I'm tired. It it was a long weekend. It was a long weekend, a busy weekend. And it's only Monday, but I'm already looking forward to Friday. I'm looking forward to Friday. I'm looking forward to just sleeping, catching up on some rest. April for me should not be too bad, but I did warn you guys that I'm going to disappear. I'll try my very best to be here Monday through Thursday. I mean, it depends on how far we get with Karen Reed. Like, if the trial is full force, then I'll be here. Okay, if the trial is really full force, I'll be here. But if it's still just jury selection, then I'm gonna disappear a little bit. I'm about to pull El Houdini. Yeah, but my April should not be too crazy because I've already started on demands. I have some demands that I have to get out. My clients have they're squared away. I don't see, unless something really happened out of the ordinary. Unless there was something that happens, if something happens out of the ordinary, then sure. Then my April kind of gets turned upside down. But other than that, I should be here to cover Karen Reed. All right, Brooklyn Benji. Shout out to shout out to the replay crew, but I'm really tired. I'm exhausted. I'm going to call it a night and we will reconvene tomorrow. I hope you guys have a good Tuesday, and Benji have no, is it Tuesday? I don't know. I'm confused. I'm confused, but I'm definitely calling it a night. I'll be back tomorrow, but I'm tired. I'm tired. All right. Bye, Benji. Enjoy your Monday. Enjoy work.